Legal, and if we're ready to go, I'll begin. By way of introduction, this is going to be a presentation on the Court of Appeal decision in the Grafton Connor case, which, as many of you who were present for the loss prevention seminar will know from Nancy Murray of our office, it was one of the most significant decisions on broker liability in Atlantic Canada, and perhaps since the decision in Fines Flowers. One of the reasons, of course, is that it's a trial decision, and so often these matters don't go to trial. And the advantage of having a matter proceed to trial is there's a full hearing of the evidence. By way of introduction, I'm at the law firm of C3 Legal in Halifax. We handle many of the broker liability cases for your underwriter in that regard. I've been in the practice of law since 2007. I've been admitted to the bars of Nova Scotia, Alberta, and New Brunswick. I've handled matters in 5 Canadian provinces, and I handle all matters of insurance law, including CGL, municipal liability, auto accidents, environmental, E&O, on behalf of brokers, financial advisors. I've done municipal inspectors and real estate agents. So without further ado, I'm prepared to begin. As I've indicated, Grafton Connor is one of the most significant cases that has come up in the Canadian jurisprudence on broker liability in some time. The trial decision came down June 30th of 2015, and the Court of Appeal reversed that decision in part June 15th of this year, so this month, or last month rather. By way of review, before we get into the case, I'd like to review the broker's duties and relationships. There is, of course, the duty of care. Broker being in a special relationship with the customer always owes a duty of care to ensure that the customer's interests are protected. Related to that is the duty to act in good faith. There's a duty to ensure that the broker looks after and places ahead of his own duties or her own duties the interests of the customer. And there's, of course, the duty to follow the client's instructions. So when you receive instructions, it's important to make sure, firstly, that they're properly documented and that they're followed strictly in order that you don't go astray and do something that was not authorized, and to make sure that all of the coverages that are required are in fact covered. The duties of care are owed to the carrier, that's the insurer, to ensure that that there isn't a risk that's taken on that was outside of the scope and outside of what was authorized. There's, of course, the duty owed to the customer to ensure that all proper and necessary coverages have been placed, and there's often duties that are owed to third parties. For instance, in the case of mortgagees, where there's a first loss payee. The duty to the insurer involves staying within the brokerage agreement. So again, to accept and present risks that are within the authority of the brokerage agreement, to follow all of the underwriting guidelines, and to act in the best interests of the carrier. That is, to present accurately the risks that are to be underwritten, so that all of the risks are fully understood, and none are taken on that wouldn't be within the scope of the underwriting guidelines of the insurance carrier. As I've indicated, in that regard, the duty is to properly disclose all of the material information and satisfy all of the underwriter's requests. The key is not to place coverage on risks that the carrier would not accept. And with regard to your own clients, the duty is to make sure that all of the exposures are covered and to make sure that the client is aware in writing of gaps in coverage. Now this figured large in the Grafton Connor case, and in fact, as you'll see, it was at the heart of the appeal decision as well. The leading cases that deal with broker liability in Canada are Fines Flowers and Fletcher and Manitoba Public Insurance. These are the seed cases. These are the cases from which all of the duties are understood. They're referenced in virtually every broker liability case. Now, with Fines Flowers, it stands for the proposition that the broker is required to insure against all foreseeable risks where there is instruction to do so. It involved a case where the broker was insuring a greenhouse. What happened is that the boilers failed and the greenhouse ended up freezing. The instructions that the broker received was to cover off all insurable risks, and in fact, that wasn't done. There was only some partial coverage, and so as a result, the risk that materialized wasn't covered. That risk of wear and tear would have been covered. It was available in a policy, but the broker never informed the customer, and of course they were found liable. So as I say, it stands for the proposition that a broker has the duty to ensure that all foreseeable risks are covered off. Fletcher and Manitoba Public Insurance is a slightly different case. It stands for the proposition that a broker is required to offer competent advice to the customer. It involved the failure to place an SEF 44 coverage on an auto policy. There was never instructions to place an SEF 44 coverage, but it was the premiums are inexpensive and it was important coverage in that case. And so the failure to advise the customer of the availability of that coverage was found to be negligent. And as I say, those are the principles that are at the heart of all broker liability cases. The courts have set a fairly high standard when it comes to dealing with brokerage cases. Courts see the brokerage community as offering professional advice, and in that capacity, there is a duty to ensure that the advice is in all ways competent and meets up to the standard and the expectations of the customer. And the courts see that as being a fairly onerous duty. There's a duty to become very informed about the business of brokerage, about the client's business, and to offer advice that covers off the insured, that meets the insured's duties. And in many cases, that involves going a bit beyond what's simply related. And that's, again, that became an important issue in the Grafton Connor matter, as we'll see. The duty of care in brokerage cases is one of it's a relationship of proximity. It's covered off in many ways by the test for negligent misrepresentation. The negligent misrepresentation often being that there's coverage in place when it's not, or it's available or not available when it is. And it's a duty of proximity, as I say. The proximity means that there's a special relationship. So what the courts look for is a special relationship that gives rise to a duty of care. And in the brokerage situation, that's almost taken for granted. The court also looks for a representation that is untrue, inaccurate, or misleading, and that the statement having been negligently made. And that there is the heart of the brokerage relationship, where the negligence arises. The negligence is generally prevented if you become informed about the client's business. There should be reliance on a representation and detriment in the sense that the customer suffers damages, and that's what's necessary to establish liability and cause of action. In Fines Flowers, the duty was to provide information about all available coverages and to make recommendations as to what the client requires. The court made a distinction between instructions to provide full coverage and instructions to place a particular coverage or a particular insurance to cover off a particular risk. If the instructions are for full coverage, there's a much higher duty on the broker. And if there's particular risks that cannot be covered off by insurance, there's a duty to advise the client about that so that the client is aware that those risks are not covered and at least enable the client to find coverage elsewhere to mitigate that risk in other ways. The scope of the duty is to place the coverage that's requested, and in order to do so, the broker needs to use reasonable skill to obtain coverage or advise if the coverage is not available. If there's no specific instructions, in other words, against the broker. The trial judge held that the broker was negligent, but the insured was also negligent in the way that it handled the application and its dealings with the broker. The key findings of fact, and these relate to what happened on appeal as well, are as follows. The court found that the statement regarding whether the building had sprinklers or not originated with the broker. after year, the insured had the opportunity to correct the misinformation. His client's business in order to assess foreseeable risks and insure his client against them, then he must do so. It goes without saying that an agent who does not have the requisite skills to understand the nature of his client's business and assess the risks should not be insured against, should not be offering this kind of service. So what does that mean in the end? That is an exhortation to fully understand the client's business and to be in a position to properly protect that client by way of insurance. So if there is a specialty line of business where you may not have access to the coverages that are required, then the agent should probably refer a kind of that sort of a risk out. But nevertheless, returning to Graft and Connor, in the end, both the broker and the owner were found equally liable for the loss. And that was a $2.7 million loss, so pretty hefty. The broker assumed that the owner's manager was experienced in matters of commercial insurance, and the owner of the company assumed that his manager knew about commercial insurance. And that, of course, was to everyone's detriment because nobody actually verified just how familiar with commercial insurance the manager was. The manager assumed that the broker had obtained and warranted the accuracy of the information in the form. So in other words, the manager assumed that the broker was just, had verified the information himself. The manager evidently didn't know the meaning of the term business value in the application. Should have known that that really means replacement cost and not book value, which is quite different. And as it turned out in the loss, the property was grossly underinsured. But because there were multiple operations in site, multiple operations and sites covered under the policy, there wasn't, the co-insurance penalty clause didn't actually get triggered. Now, on appeal, the broker and the property owner appealed against the findings of liability. So they each one argued that the other should be fully responsible. They argued that they shouldn't be found liable in the first place. And the underwriter, which was a Lloyd syndicate in this case, argued that the trial judge's decision could be upheld. They opposed the appeal naturally, but they also argued that the decision could be upheld simply on the basis that there was a finding that the property owners were reckless, and that would also uphold the decision. It wasn't something that was relied upon by the trial judge, but they argued that the findings of fact amount to recklessness. Recklessness is, as you'll see, it's an interesting argument from the point of view of the appeal, but I'm going to relate the argument regarding recklessness into one of the takeaways that I would urge you to take from this appeal. There were numerous grounds of appeal, but the three that are key for...
As far as I know, Keith has got it. Or not Keith, but Bashir's got it.
I hear, it sounds like somebody's microphone is still on. So if there's a question, I'm happy to take any questions, but please mute your microphone while the presentation is going. Now, if there is a question, I'll just pause here. If there's a question, by all means, just put it in the chat box, and I'm happy to address that. But in the meantime, I would ask that people please mute their microphones. I do hear some typing going on in the background, so if you're typing in the background, your microphone is now off, or is on, so please mute it. Going forward, there were numerous grounds of appeal, as I've said, but the key grounds, the ones that concern us today, were these. Grafton Connor's owner, who's an individual, knew about the construction of the building and of the lack of sprinklers. And so the argument was that that knowledge should be imputed to the company. And therefore, it wouldn't matter if the employee who was dealing with the broker didn't know about the construction. The company knew about it and ought to have verified the application. So that was the first ground of appeal that we are concerned with. The second ground of appeal that we're concerned with is whether or not the trial judge applied the correct standard of care. The argument was that the requirement to go and make sure that the person that you're dealing with can actually answer the questions of the applications going a step too far. And as I said, that there was an argument about recklessness and whether or not the property owners could be found to have been reckless in placing and renewing the insurance policy such that that negligence was actually what caused the loss. On the first ground, the insured's knowledge of the property attributes, the judge said that the broker should have investigated the knowledge and ability of the property owner's representative to provide correct answers on the application. That is a finding which caused us a lot of concern in handling these matters for you. It's quite an onerous burden to put on a broker to make inquiries with the person that you're dealing with, and it almost amounts, and that was what was one of the matters that was appealed. It almost amounts to a duty to verify information that really is something that the customer would know. Up until this case, there really wasn't any kind of case law that would have supported that sort of a duty. The trial judge said that whether that duty arose or not depended on, and in quotes specifically, the complexity of the risk and whether that information is within the representative's personal knowledge. So it would have imposed a duty on the brokerage community in dealing with customers to make inquiries with the representative of a business as to whether the answers that they're giving you on an application is something that they know personally, that they've gone out and checked, or whether they're relying on somebody else's knowledge in order to answer those questions. That's as I've said, it's a very onerous burden to put on the broker. The Court of Appeal said that the individual who owned the corporate insured knew about the details of the construction, and that knowledge, this is the important part, that knowledge was the company's knowledge. So the owner knew that the building was made of wood and stone, combined construction, knew that the building had no sprinklers. And just because there was an employee who didn't know that, didn't change that. So the duty was still, the Court of Appeal found that the duty was still on the company to verify that the information that it was providing was accurate. It said in the end that they ought to be more careful in signing the insurance application. At 120, this is again, and I hope you'll bear with me as I read some of these, because it's these sorts of passages that end up getting quoted over and over again when these matters proceed to court. We end up, as lawyers, we end up quoting certain passages to each other, partly to demonstrate how smart we are, but also because it demonstrates the burden that's actually on the other side. So the trial judge, what the Court of Appeal said, the trial judge seems to be suggesting that because neither Mr. McMullen nor Mr. Raymond, being the representatives, had personal knowledge of the true state of affairs at the North End pub, Beaufort Investments somehow gets a pass because of that lack of knowledge. As I went into details in these reasons, the applicant for insurance in this particular circumstance is Beaufort Investments. Beaufort had the knowledge that the property was unsprinklered and not of masonry construction. So, and as I've said, once that knowledge is in the company, it's for the company to make sure that the application being submitted is actually accurate. The Court of Appeal had difficulty with the fact that the trial judge's reasons would have required brokers to make inquiries as to the knowledge and sophistication of their clients. As I've said, that runs contrary to numerous other decisions that have come before this, which is one reason why this decision caused such a stir. The trial judge said that the decision would amount to a duty to verify information that's in the insured's knowledge. That's something which is commercially unreasonable. It's asking too much in an ordinary commercial environment to have brokers go that far. Here, even if you could say that the duty to make those sorts of inquiries depends on the complexity of the risk here itself wasn't complex. The risk wasn't complex. And the complexity of the risk isn't to be confused with the description of the property. So what might be insured may be complex in terms of construction. Certain particular risks, if it were a CGL policy that we were dealing with as opposed to a property policy, the risk being insured might be complex or not. The operations may be complex, but the risk may not be, and it's important to draw a distinction between the operations, the property itself, and the risk itself. The property owner understood the importance of the construction and sprinkling to the risk. The property owner fully understood that if this was a wood construction building or if it was a completely stone building, that presents a different risk for the insurer. And they understood that sprinklering made a difference to the risk. And that wasn't something that they needed special knowledge in order to answer. So knowing that those are important issues, it was incumbent on the property owner to ensure that the application was accurate. Now at trial, the trial judge said that the broker ought to have made inquiries into the ability of the property owner's representative to provide accurate answers on the application. The Court of Appeal was very critical of that point. It said that the owner, although clearly the owner knew that there was mixed construction, it's a step too far to say that the broker has to verify that information. Past court decisions have said that the duty to provide accurate information is on the insured, on the customer. The insured has a duty to read the application, make sure that the application is accurate, and it's not enough for a sophisticated insured to simply say, well, I didn't read the decision or I didn't read the application. It may be different. I pause to note that if you are dealing with an unsophisticated insured, that duty may well arise. So this deals with sophisticated property owners, sophisticated people that are knowledgeable and experienced in business. If you have a new business owner who's never operated anything more complex than a lemonade stand, you may be dealing with a different situation. So there may be a much higher duty to make inquiries. So that's this case. On the question of recklessness, the court, or the underwriter filed what's called a notice of contention. Now, a notice of contention is a document that you file on an appeal when you are trying to uphold the trial judge's decision. Now, the party that's responding to the appeal in that case can just not file a notice of contention, just oppose the appeal. But what the notice of contention does is it allows the party to argue that the decision should be upheld for reasons that are not necessarily stated in the trial judge's decision. Here, the underwriter argued that the findings of fact that the trial judge made amount to a finding that the property owner was reckless in the placement of insurance. So why would they make that argument? Well, they'd make that argument because what it does is it negates any argument that the misrepresentations were unintentional. And one of the arguments that was raised at trial was that the policy contained a provision in it that said that any unintentional misrepresentation shouldn't void the policy. Now, at trial, and that part of the decision was upheld on appeal. The court said that yes, that might be true for certain things, but it doesn't hold when the unintentional misrepresentation deals with something that's material to the risk, so it wouldn't apply in this case. Here, what the court said, what the underwriter did to try and negate that argument is to say that this isn't just something that they unintentionally misrepresented. There was never any real belief in the truth of the statement because it's no longer unintentional. They were reckless as to whether or not the statements were true or not. The effect would be to void the policy. In order to make out recklessness, it's not necessary to have an intention to deceive. All that's necessary is to demonstrate that this was something more than just bungling or gross negligence. There has to be a lack of any honest belief in the truth of the statement. Here, among the findings of fact that the trial judge made, Grafton Connor knew, that is to say the owner knew that there was mixed construction and not just sprinklers. The representative from Grafton Connor knew that information was important to the underwriter. The representatives didn't tell the broker that they were relying on the broker to complete the forms accurately. They didn't actually underline the fact that they were relying on the broker. The property owner's representatives didn't ask anyone about the true construction of the property. So the employee of the property of Grafton Connor didn't actually verify that the information he was providing was correct. Every year, they were provided with a copy of the application. They had the opportunity to make sure that it was correct and update it if it was necessary, but they never did that. The court was also critical of the fact that the owner of Grafton Connors, who had the knowledge of the construction and who knew about the sprinkling, never instructed his employees about how to fill out those forms, never ensured that the employee had the necessary knowledge so that when he went about doing his job, securing the necessary insurance, that he had the necessary knowledge. The owner relied on the broker to complete the application, but then never made any inquiries with the broker as to where the broker got the information that was being put into the form. The court also got hooked on the fact that it was clear that it would be very simple to tell whether or not the pub was sprinklered or not. Walking in and taking a look around, you would immediately see whether there were sprinkler heads or not sprinkler heads. And if there were no sprinkler heads, then that's something which the employees, knowing the property, being in the property, if not on a daily basis, regularly, they should know whether or not it's sprinklered. And so it would be incumbent on the owners to make sure that the information was correct. The owner himself never actually looked at any insurance applications after 1996. What had happened is that in 1996 he hired a couple of people to help him operate the business, but then never really gave them any instructions and never looked at anything that they did. Just sort of assumed that the representatives knew what they were doing and allowed them to go about their work. They were aware that the broker had never actually physically inspected the pub. So despite what was going into the forms, despite never giving the employees instructions, never making sure that the employees had enough knowledge to complete the forms accurately, or at least make sure that they were completed accurately, never actually, they knew that the broker never actually went in and never inquired with the broker as to where the broker got that information. And so the Court of Appeal took all of those facts and concluded that Grafton was actually indifferent as to the truth of the statements that were being made. So in that regard, and based on that, the broker was found not liable. So the finding of 50% liability against the broker was reversed, and the owner was found to be 100% liable. Now, why is recklessness important? This case is overall a very good result for brokers. It rightly created a spike of fear in the sense that there was quite a duty that was imposed by the trial court, and that duty was reversed on appeal. But what I would urge is that I would urge against complacency. If there is, in the course of preparing an application, in the course of dealing with an insured, if there's some reason to think that the information that you're being provided might not be accurate, or that the person providing the information might not be in a position to answer those questions accurately, although this court says that it's the duty in the end is on the customer, is on the insured. If you have a reason for suspecting the accuracy of the information, you will not get a pass. And so that's why I kind of glom onto the question of recklessness, because it basically involves closing one's eyes as to whether or not the information being provided is true or not. It's sort of a quantum leap in terms of when liability arises. Yes, you're not required to verify information that you know is within the insured's knowledge. But on the other hand, if you have reason to think that the information that you're being provided is inaccurate, you will not get a pass despite graft and Connors. In my experience dealing with other errors and omissions programs, that becomes key, because the courts, no matter what, the courts will view you as the professional. They will impose a very high duty on you. They will find ways, they will at least look very hard to find ways to compensate they will look for ways to compensate an insured if they see that the insured is basically innocent. This litigation was clearly time intensive. The loss happened in March of 2007. The trial didn't happen until another 7 years after that, and it was 20 days over 3 months. It was clearly very expensive, very stressful. So what I would urge is practice defensively. Consider whether or not there's a reason to think that what you're being told might not be accurate, whether not accurate in the sense that it doesn't make any sense, it doesn't accord with common sense, or that the person providing it has no basis for being able to say that this information is accurate or not. Is there a reason to question what you're being told? As I've said, overall, this is a very good result for brokers, but I urge against complacency. There's no duty to verify information. You should still ensure that there's no reason to suspect that it's inaccurate. With that, I'm happy to take any questions. Okay. From Kathy, the question is whether it would be prudent to always ask for an inspection. In my opinion, that's I don't think it's necessary in every case. But if you've got, for instance, it really depends on the circumstances. So if you've got a customer who's insuring a number of different properties, the employee that you're dealing with might not be totally familiar with them, is new to the company. If the building is older and hasn't been inspected in a long time, if you think that there has been renovations of some sort that might mean that the information that you had on a renewal might not be accurate, then yeah, it's worthwhile to conduct an inspection. I would also say that it's probably wise to, again, depending on the risk and in accordance with common sense, it might actually be a good idea to go and take a look around to see if there's anything that jumps out at you as well. Well, that's a two-edged sword. So would it be prudent to always ask for an inspection? I think that you have to ask yourself whether an inspection is necessary. I don't think it should be done as a matter of course in all cases, but it's definitely something to think about, and if it, under particular circumstances, to see if it makes sense. Will copies of the presentation be made available for download? I believe Carrie's making the slides available, and there will be this session is being recorded, so you'll be able to listen to my dulcet tones at any time in the comfort of your own office. Any other questions?
There are no other questions. This is Carrie Foley from IBANS. I just wanted to say thank you very much to Franco for the webinar, for the presentation this morning. It was very informative. And as he did mention, pardon me, I do have copies of the presentation. So if you'd like one, you can just send me an email, carrie@ibans.com, or I am recording the session, so I will have that posted to our IBANS YouTube channel as well at some point, hopefully by the end of the day.
Well, if there's no other questions, it was a pleasure giving the presentation, and again, feel free to contact me outside this if there's anything that you would like to discuss.
Thanks a lot, Franco.
It's a pleasure.